Constitution and welcome my colleagues, most especially the ranking member on the subcommittee, Senator Cruz. Thank you so much for your cooperation in scheduling this first hearing, and I look forward to this kind of collaborative effort going forward. And I know we've been joined by Senator Grassley, the ranking member of the committee. I'm going to turn to you after Senator Cruz, and I think we may be joined by Senator Durbin for some opening remarks as well. Last month, the Judiciary Committee held a very important hearing, as my colleagues know, on Constitution and common sense steps to reduce the epidemic of gun violence in this country that has recently claimed so many lives in Atlanta, Boulder, Indianapolis, and elsewhere. Gun violence is a real problem. We all know it. But there are also real solutions. And I believe strongly and passionately that we have a path to put some of those solutions into law during this session, and I believe we can with bipartisan cooperation. I'm not naive. I don't believe that all gun violence prevention proposals will be adopted by unanimous consent, but I hope this afternoon at least we can focus on one topic where there does appear to be at least some measure of common ground. Extreme risk orders, also known as risk warrants, that's the name in Connecticut we've adopted, or red flag laws. Whatever you call them, we know they save lives. We know that red flag extreme risk orders save lives. They are practical and proven tools that allow law enforcement under some statutes and others, including family members, to keep guns out of the hands of individuals who possess and pose a danger to themselves or others. In other words, separate people from guns when they are in crisis. Firearms make dangerous decisions far more deadly and irreversible. Just to give you one example, among commonly used methods of self-harm, firearms are by far the most lethal. For people who seek to take their own lives, the fatality rate is approximately 85% with a firearm. It is 5% by any other method. Firearms are used in less than 6% of suicide attempts, but they account for more than half of the suicide deaths. In 1999, my home state of Connecticut became the first in the nation to enact an extreme risk order. We call it a risk warrant. Studies have shown that in the first 14 years of Connecticut's law, for every 10 to 20 risk warrants issued, at least one suicide was prevented. In addition, many of those who tried to take their own lives were compelled or persuaded to seek help, professional help, that made a real difference in their lives. That isn't some sort of abstract statistic. States across the country have used extreme risk or red flag statutes as critical suicide prevention tools. In Portland, Oregon, law enforcement was able to remove 10 firearms and bar future firearms purchases after a man called 911 and threatened to kill himself and his 3-year-old son with a gun because he was frustrated that he was not able to make a child support payment. The same is true probably in all of your states. I know you have heard these stories. I'm not going to recount more, but I will put my full statement in the record. These laws don't just prevent suicide. They've also been used to stop mass shootings, homicide, terrorist threats, and hate crime. Authorities in Florida use the state's extreme risk order law to remove an AR-15 from a high school student who had said he would kill himself and his ex-girlfriend if they didn't get back together, if she didn't get back together with him. As my colleague, Senator Graham, has pointed out, the Parkland shooting resulted after the killer in that instance practically put an ad in the phone book saying he was going to shoot people, but authorities there couldn't stop him for lack of a red flag statute. After it happened, they adopted one in Florida. These laws are also bipartisan among the American public, in state legislatures and in Congress. In fact, polling has found that 84% of Americans, including 78% of Republicans, support red flag laws. There are now 20 jurisdictions, blue states and red states, with these critical tools in place. And others are on their way to passing and implementing the laws. President Biden has announced that the Justice Department will soon publish model legislation for states that will help them to adopt these statutes. And I've worked closely with not only my colleague, Senator Graham, who's been very constructive, but also Senator Feinstein, Senators Rubio and Scott have introduced their own bill, and I look forward to making progress. Let me just touch 2 points in conclusion. First, Indianapolis. The tragic events in Indianapolis show just how crucial effective implementation and enforcement is to the success of these efforts. Indiana has a strong red flag law named in honor of a police officer who was killed in the line of duty in a situation that might have been prevented had a red flag been in place at that time. Earlier this month, as we all know, a shooter killed 8 people at a FedEx warehouse in Indianapolis. Several months prior, police had taken a shotgun from him after his mother reported that he might try to commit suicide by cop. Law enforcement knew he was dangerous. Prosecutors just didn't use Indiana's red flag law to bar that individual from purchasing new guns, and he did, in fact, purchase 2 semi-automatic rifles in the months that followed, which he used in that massacre. Some have said that Indianapolis shows red flag laws don't work. They ought to be scrapped. I think that point is ridiculous. There are 6 million car accidents in the United States every year. That doesn't mean we throw out seatbelt requirements or speed limits. We insist on more effective enforcement of those laws that might have prevented those accidents or crashes or deaths. What the preventable loss of life in Indianapolis does prove is that even in jurisdictions where these laws exist, effective implementation is critical. We will hear today from witnesses who will tell us how federal grants would support training for prosecutors and others to enhance those states' development and effective use and enforcement. All of us who've been in law enforcement know laws are dead letter unless they are implemented and enforced effectively, and our proposals on red flag statutes are designed to provide the resources, the training, procedures, other kinds of basic nuts and bolts steps that are important here. Due process. To those critics who raise the specter of due process concerns, let me just say, extreme risk orders provide robust due process protections that comport with both the Constitution and the Supreme Court precedent governing due process considerations, and that is my goal here and in whatever we do, formulating and passing red flag statutes, to provide models and require that those grants and resources provided to states are conditioned on due process protections. These orders are temporary. They're used only by judges. The judges have to take evidence. The determinations are based on those evidence. The evidence is submitted under penalty of perjury. And when a temporary order is issued, but before it becomes permanent, the individual subject to it is provided with notice and an opportunity to both challenge the evidence against them and present evidence of their own. And once the order expires, the individual subject to it must have a firearm returned to them, so long as they are not otherwise prohibited from having it. So I think we are in an era that feels very different about gun violence. I'm hoping that we can reach bipartisan consensus. Gun violence isn't inevitable. Extreme risk order laws, red flag statutes prove it. And I, again, welcome my colleagues this afternoon and hope that we will indeed make progress. Thank you to all of my colleagues. I turn to Senator Grassley. I understand he would like to be recognized because of time constraints, and I'm happy to do so.
As ranking member of the full committee, I thought I ought to come and show my support for this hearing and the very important issue of crimes that are committed with individuals struggling with mental health issues. I was going to start out by talking about the Indianapolis situation, but Senator Blumenthal already covered that very well. So I will move on to a fact that earlier this month, a tragedy struck when a 25-year-old man rammed his vehicle into the security barricade just mere steps from this chamber. As we all know, this man's actions tragically took the life of U.S. Capitol Police Officer Billy Evans, while the Capitol's attackers' exact motives is unknown. Social media profiles indicate the man was a follower of a group that reportedly holds racist, anti-Semitic, anti-LGBTQ beliefs. It's too early to tell if those beliefs motivated this man to commit the act of terrorism, but what is clear is the man was struggling with mental health issues. Today we're talking about red flag laws. I think that we should be looking into possible solutions for gun violence, so a hearing is the right thing to do. And so I thank you for having this hearing. I do think that red flag laws are generally a state rather than federal issue. I also want to state my strong belief that any state that does decide to enact red flag laws should do so with strong due process protections to safeguard an important constitutional right. And I just heard what Senator Blumenthal said about those strong due process laws, and just want to make sure that they're always followed. But I also want to say that red flag laws are scarcely the only option for ensuring the persons with mental issues are prevented from engaging in violence or self-harm. So I turn to some legislation I put in that has bipartisan support called the Eagles Act of 2021, a common sense piece of legislation building upon what the Secret Service successfully does over a period of decades. This bill carries the namesake of Parkland, Florida, Marjorie Stoneman Douglas High School mascot, the Eagles, and it's a tribute to the 17 Eagles who tragically lost their lives 3 years ago at the hands of a fellow student who long struggled with severe behavioral problems and mental health problems. And if he'd been sent to get help that he ought to had, he would have been in the database and wouldn't have been able to purchase a gun. This legislation helps proactively mitigate threats of violence in our country through reauthorizing and expanding the U.S. Secret Service's National Threat Assessment Center, also known as NTAC. A family member, teacher, coach, fellow employee, or neighbor's ability to observe someone's behavior, home life circumstances, work-life factors, and other potential stressors, coupled with NTAC's threat assessment training, can prevent harmful outcomes from occurring. But in order for this to be effective, we need to increase NTAC's capacity to continue their research and threat assessment training. Just this week, the Eagles Act got the resounding endorsement from the National Association of Attorneys General. 40 attorneys general from all over the United States believe that intact, proactive approach is critical to violence prevention. We cannot afford to ignore their urgent pleas of assistance. So I ask my colleagues, hopefully all of them, to support the Eagles Act. The more research and threat assessment and training that can come from it, we can provide, the more violence we can prevent. Thank you, Senator, for bearing with me while I come.
Thank you, Senator Grassley, and thanks for your input. You know, we are really working, as Senator Graham and I have done for quite some time over the years, to adopt an approach that is as inclusive as possible, that is respectful of due process, and that meets all of the challenges that you've raised. So thank you for being here today. With your permission, Senator Cruz, I'd like to turn to Senator Durbin if he... Senator Cruz.
Thank you, Mr. Chairman. There's no one in this country who isn't fed up and furious when we hear that another monster has used a gun to take an innocent life. And there isn't a person in this country who isn't heartbroken when they learn about another suicide. Every life is a gift from God, and every innocent life that is lost is unique and a tragedy. I can tell you, in Texas, we have seen far too many mass murders at the hands of deranged and sick individuals. I was in Santa Fe the morning of that shooting. Santa Fe High School is less than an hour away from my house. I was in El Paso at the Walmart after another mass murder. I was in Midland, Odessa after yet another. I was in Dallas, where 5 police officers were murdered by a deranged radical. And I was in Sutherland Springs, in that beautiful sanctuary where a monster murdered innocent women and children. I care deeply about stopping violent crime, and gun crime in particular. I've spent much of my adult life in law enforcement, trying to stop violent criminals who prey upon the innocent, and working to ensure that they receive the most stringent punishment. But one thing is abundantly clear. If the objective is to stop violent crime, restricting the rights of law-abiding citizens doesn't work. In fact, it typically makes crime worse, because when you disarm law-abiding citizens, you make them more likely to be victims. 2 years ago, when we had a hearing on red flag laws in the full committee, I said at the time that those laws could potentially be part of the solution set at the state level. And I still believe that. The states are laboratories of democracy. They are the proper place to debate the substance of red flag laws. We shouldn't be imposing a federal standard or putting the federal government's very heavy thumb on the scale with coercive grant programs, especially when 19 states and the District of Columbia are already experimenting with these laws. But I also said, and continue to believe, that even at the state level, laws must be narrowly targeted to those who pose an extreme risk while simultaneously giving full force to the fundamental rights of all law-abiding Americans. Many of the state laws that have been implemented fall short of this standard in one or more ways, and none of the Democrats' current proposals come close to meeting it. Rather than taking a measured and respectful approach, radical gun control advocates see red flag laws as a way to open the door to comprehensive gun control. One of the drafters of Connecticut's red flag law, which we heard about earlier, the first in the country, admitted this last week on CNN, stating that these laws only work as part of comprehensive gun control legislation. The fact is, Democrats don't want Americans to own guns. In August 2019, a television interviewer asked then-candidate Joe Biden the following question. So to gun owners out there who say, well, a Biden administration means they're going to come for my guns. Biden's response? Bingo. They're not hiding it. So it's no surprise that this administration and that Democrats in Congress and anti-gun groups are all pushing red flag laws that will take guns from law-abiding Americans. In Connecticut, for example, 32% of confiscation orders are overturned when a judge finally hears both sides of the story. And this is after the government has already seized the firearm. This means that 1 out of every 3 people who has his or her firearm seized by the government under Connecticut's red flag law is an innocent, law-abiding citizen. That is an unacceptable rate of protecting constitutional rights. One reason that the error rate is so high is that most of these laws don't even purport to satisfy due process. Every red flag law currently in operation permits the government to order the confiscation of firearms without notice to the individual, and a hearing only to follow at some later time. Ex parte hearings may be necessary in some extreme cases, but they shouldn't be the default standard. Moreover, in many states, the word of a spurned romantic partner or disgruntled coworker is sufficient to meet the watered-down standard for unilateral, albeit temporary, deprivation of Second Amendment rights. Put simply, red flag laws empower the government to take firearms first and ask questions later, often much, much later. No one would tolerate these procedures to deprive Americans of any of their other fundamental constitutional rights. But Democrats don't care that law-abiding Americans lose their rights under these laws because they don't believe in the Second Amendment and the right to self-defense. In a shockingly candid statement, President Biden's nominee to lead the ATF told one of the witnesses testifying today that it didn't matter if a law-abiding citizen lost their rights due to red flag laws because the disarmed victims can just purchase a replica gun to scare criminals away. That is an answer that reveals a contempt for the Second Amendment right to keep and bear arms. And it's dangerous. The Second Amendment is not about hunting. It's not about recreational shooting. It is about the fundamental right to protect our lives, to protect our homes, to protect our families. It's about the right we have if somebody comes into our home at night seeking to harm our children, to defend our children, and to defend our lives. The red flag laws being pushed by Democrats and gun control activists are designed to deprive Americans of that fundamental right. And for what? As one of today's witnesses wrote in 2020 after reviewing all of the available literature, quote, no research has found any statistical reduction in crime, including mass shooting fatalities, from confiscation laws, and studies about suicide reduction show mixed results. That's what the data show. We need to act, and we need to act forcefully to stop gun crimes. And I have introduced legislation and fought for legislation to do that. But federal red flag laws, I don't believe, are the answer. We don't need to impose Connecticut's dismissive approach to Second Amendment rights on the entire country. Thank you.
Thanks, Senator Cruz. Just before we go to Senator Durbin, I want to make the point, Senator Cruz. I can't speak for every Democrat. I can speak for myself. I am not against Americans owning guns. I am very much in favor of the law as it's interpreted by the United States Supreme Court that Americans have Second Amendment rights. I would oppose any law that took away Second Amendment rights. As we know, no right is absolute. And so far as the Connecticut study is concerned, we have been through this issue again and again and again. That 2014 study reported, quote, judges ruled that the weapons needed to be held by the state 68% of the time. In the remaining 32% of the cases, the guns were not given back to the individual. The orders were not overturned. In many of those cases, the guns were given to someone else, so the state did not have to keep them, a family member or someone else. In only 10% of known cases in risk warrants in Connecticut were the guns actually returned to the individuals. Now, we can debate the percentages one way or the other, but I just think we need to be very clear on the fact that these red flag statutes preserve constitutional rights, that misleading numbers and statistics can be cited. The plain fact is that they save lives. I'm going to turn to the chairman of our committee.
Thank you, Mr. Chairman. Senator Blumenthal, I realize this is your first hearing as chair of the Constitution Subcommittee, and I want to thank you for starting off this Congress with a series of hearings on critical topics, including the epidemic of gun violence, and it is truly an epidemic. In my home state of Illinois and the city of Chicago, which I'm honored to represent, we have the equivalent of at least one mass shooting every weekend. When you put together the number of people who are injured and killed by gun every weekend in the city of Chicago. I always thought the problem with those numbers is they don't hit you in one big number. They just keep coming at you every single weekend. And if it's a holiday weekend, it's even worse, dramatically worse. And the stories in recent weeks of the profligate use of guns by those who think they can never have enough guns out in circulation. We're children. Children are being shot. A 2-year-old in a car on Lakeshore Drive, a 7-year-old at a McDonald's drive-in a week ago. It's just out of control situation. And the question is, when will it reach a point where we do something effective? I thought the point had been reached on December 14th, 2012. I believe that that was the moment when a gunman murdered 20 children and 6 educators at Sandy Hook Elementary School in Newtown, Connecticut. I thought that's got to be it. A room full of little kids, look just like my granddaughter, gunned down in the classroom, 6 educators. Finally, we're going to do something. Countries have responded to far fewer deaths by changing the whole approach to guns. But sadly, in the months after Sandy Hook, we held hearings. We voted on some gun safety reform, but even key reforms, not universally, but just overwhelmingly supported, like universal background checks, were filibustered and failed. While Congress sits here again and fails to act every day, the deadly toll of gun violence grows, not just in Illinois and Chicago, but across this country. I'm not giving up on common sense reforms, and I know Senator Blumenthal is not either. I want to say one thing in prefacing my remarks. When we often speak about people who are mentally unstable, who shouldn't be owning firearms, I hope we quickly add the vast majority of people dealing with mental illness are not violent people, and they're not dangerous people. And we shouldn't assume that they are. Many of them need treatment and help, and they can lead perfectly normal and safe lives for themselves and others. But there are exceptions, and many times deadly exceptions. Look at what happened in Indianapolis just 2 weeks ago. A 19-year-old gunman murdered 8 people at the FedEx facility. It was horrific. In March 2020, last year, that gunman's mother had contacted the Indianapolis Metropolitan Police Department to inform them that her son's recent firearm purchase concerned her because he had suggested he planned to threaten police with a firearm in order to provoke a shooting. The police department placed him on a temporary mental health hold and removed the shotgun from his possession. But prosecutors, for reasons I don't know, never filed an extreme risk protection order petition under Indiana's law. In July and September of 2020, the gunman was able to legally buy 2 semi-automatic rifles, which he used to commit this mass murder. Let me tell you my experiences in Illinois, which belie some of the extreme statements that have been said about these laws. We have a firearm restraining order that took effect in 2019. The law allows family members and law enforcement to petition a court to temporarily remove firearms from the possession of an individual who presents a significant risk to himself or others. According to information reported by the Illinois State Police, a firearm restraining order has been issued 59 times under this Illinois law. In 2 years, a state of 12.7 million people, it's been used 59 times. We have 2.2 million licensed gun owners in Illinois. So clearly, this is a targeted intervention. This is not a broad, sweeping thing denying due process to legal gun owners. I've talked with law enforcement officials in Illinois who point out that it takes resources to carry out these orders. They need some help. I think this is a tool. It is not the overall answer, but it's an important tool. And in some cases, it can save lives. In Indianapolis, had it been used, I think it could have saved those 8 lives. At least we know that possibility. So I thank you for calling us together today to discuss this. And as I said at one point here, one bill is not going to solve gun violence in America. But shame on us if we reject common sense approach that most gun owners endorse as the only sensible way to take guns out of the hands of people who are dangerous.
Thank you, Senator Durbin. I'm going to introduce our witnesses and then, as is our practice here on the Judiciary Committee, to swear them in. First, Vic Bencomo is a resident of Denver, Colorado, and the current president of Colorado Gun Owners for Safety, a chapter of Gifford's nationwide Gun Owners for Safety Coalition. Bencomo is a father and a proud veteran, having served for over 20 years in the United States Navy. He's also a gun owner, hunter, and advocate for laws to prevent gun violence. He has previously testified before both the Colorado State Legislature and the United States House of Representatives Gun Violence Prevention Task Force. David Koppel is the research director of the Independence Institute and associate policy analyst with the Cato Institute in Washington and adjunct professor of advanced constitutional law at the University of Denver's Sturm College of Law. Mr. Koppel writes on constitutional law, criminal justice, civil rights, firearms, policy, international affairs, technology, politics, environmental policy, and the media. He's the author of 17 books, hundreds of newspaper and magazine articles, and over 100 scholarly journal articles. Before joining the Independence Institute, Mr. Koppel served as an assistant attorney general of the state of Colorado, and he's going to join us remotely. Kimberly Wyatt is senior deputy prosecuting attorney with the King County Prosecuting Attorney's Office. She has been with the office since 2001. She has worked on cases involving domestic violence, stalking, sexual assault, child abuse, and other crimes of violence. Most recently, she has been part of the newly formed Domestic Violence Regional Firearms Enforcement Unit. In this role, she advises law enforcement and families on all aspects of extreme risk protection orders, from investigations to court proceedings. Ms. Wyatt also works on firearm compliance cases and high-risk domestic violence firearms offenders. Nikki Ms. Gosser lives in Tennessee and is the executive director for the Crime Prevention Research Center. She became a Second Amendment activist and victim rights advocate after the brutal murder of her husband, Ben, by a man who had been stalking her. She is a graduate of the University of Tennessee at Knoxville, and she earned her degree in psychology. Joshua Horwitz is the executive director for the Coalition to Stop Gun Violence. He has spent nearly 3 decades working on gun violence prevention issues. In 2013, Mr. Horwitz helped found the Consortium for Risk-Based Firearm Policy. The consortium released a set of policy recommendations designed to promote policies that can prevent those at a heightened risk of violent behavior from possessing firearms. One of the consortium's recommendations was the basis for California's first in the nation gun violence restraining order, which passed in September 2014. I'm going to ask all of you to please stand so that I can administer the oath. Do you swear that the testimony that you will give is the truth, the whole truth, so help you God? Thank you. Mr. Bencomo, we'll start with you.
Good afternoon, and thank you, Chairman Blumenthal and the members of the committee for this opportunity to testify today. My name is Vic Bencomo. I'm a parent, gun owner, hunter, and a proud Colorado resident for over 30 years. As a retired combat veteran with 21 years of service in the United States Navy, I know what it means to be a patriot. I have seen the carnage of war and personally know the emotional and physical scars that it leaves. I am the president for the Colorado chapter of Giffords Gun Owners for Safety. We are a national organization of gun owners who support responsible gun ownership and common sense gun laws. We proudly support the Second Amendment, but we can no longer ignore that our country is in the midst of an epidemic. The daily threat of gun violence is a shocking reality in countless communities across the country, especially in our veterans community. As a veteran, I'm witnessing my fellow service members take their lives at a tragic rate. More than 17 veterans die by suicide daily nationwide. That is over 6,400 veteran suicides a year. In comparison, that is more than all the service members killed in action during the last 18 years of Operation Iraqi Freedom. Tragically, Colorado veteran suicide rate is above the national average. Out of the 173 veterans who died by suicide in our state in 2018, 112 of them used a firearm. As we know, firearms are the most lethal means used in suicides and accounts for nearly 70% of the veterans' deaths. Our veterans are a segment of the population that is uniquely positioned to own firearms. When faced with a crisis such as suicide, they often choose the most convenient and lethal form, which is a firearm. On more than one occasion, I have received a call from a wife, a concerned family member, or even a veteran who is displaying suicidal tendencies. Generally, veterans do not seek medical help. Not knowing where else to turn, the family often calls the police. However, law enforcement do have their limitations. Instead, I was the one that answered the call that night. I was the one that drove to their house. I was the one who convinced them to seek help. I was the one who took them to the hospital. I was the one who took possession of their firearms. I was the one who agreed to take custody of them once they were released from the hospital. But sadly, for 6,400 veterans that committed suicide last year, they did not have someone like me to help them. Temporarily keeping the guns out of the hands of people who have been found by a court that pose a significant risk to themselves and others is not an infringement on the Second Amendment's right. It is an opportunity for a pause, which we have seen save lives in Colorado. In 2019, I testified in front of the Colorado State Legislature to support House Bill 1177. The bill passed, and Colorado became the 17th state with an extreme risk law. As of April 2020, 19 additional states, including the District of Columbia, have enacted similar legislation. Admittedly, the path to passing an extreme risk law in Colorado was not an easy one. There were many opponents of gun safety who raised unfounded fears that such a law would lead to mass confiscations of weapons from law-abiding gun owners, or that the law could be weaponized and used to retaliate against others. But after a year of the law being in place, it has been proven to be effective without infringing on the Second Amendment right. In 2020, Colorado had 112 petitions filed by law enforcement and family members. It's important to note that only approximately 40 petitions filed resulted in issuing a risk protection order. A notable petition was used to disarm a 47-year-old veteran who threatened to shoot himself and police officers. Colorado has proven that this law works. It protects individuals' rights, doesn't allow a person's guns to be removed without real evidence, and that if a person is in danger to themselves or others. As a veteran, I have a single request to the Senate. Please do everything in your power to save the lives of gun violence and save veterans from suicide. I urge this Congress to support states' efforts to pass and implement risk protection order. On behalf of the veteran community, I'd like to thank Senator Blumenthal and Senator Feinstein for the courage and the leadership on this issue. Thank you.
Thank you, Mr. Bencomo. I'm now going to call on Mr. Koppel. Who will be joining us remotely.
Okay, great. Thank you. Thank you, Mr. Chairman and subcommittee members. As you know, the United States Senate Subcommittee on the Constitution has jurisdiction over enforcement and protection of constitutional rights and statutory guarantees of civil rights and civil liberties. I agree with the American Civil Liberties Union that gun confiscation laws may be a reasonable way to further public safety. To be constitutional, the ACLU continues, they must at a minimum have clear, non-discriminatory criteria for defining persons as dangerous and a fair process for those affected to object and be heard by a court. Persons who are blasé about due process in the firearms confiscation context should recognize that Fourth and Fifth Amendment loopholes created for one type of special circumstance eventually become widespread and normal. For example, asset forfeiture without proof of guilt, warrantless secret surveillance, and police militarization. Any procedure that forces a judge to hear only one side of a case necessarily can produce a high error rate. And Senator Blumenthal, you were right, and I will correct my written testimony about Connecticut. While we were waiting, I reviewed the study that I had cited, and you described it correctly, and I had misread it. But as another study, also in my written testimony, points out, in Marion County, Indiana, when they studied what happened when the due process hearing finally took place, 29% of orders were dismissed when the judge heard both sides of the case. In fact, in the large majority of cases where the respondent appeared, the confiscation order was reversed. People shouldn't be subjected to confiscation for exercising First Amendment rights. For example, in Florida, an ex parte confiscation order was issued against a man because of a pair of social media posts. The first was a photo of a rifle that he'd built at home, which is perfectly legal in every state, along with a caption, "It's done, hooray." The second post criticized teenage anti-gun activists for trying to take away people's rights. In Massachusetts, 84-year-old Stephen Nichols had served in the Korean War and for 6 decades as a police officer in the town of Tisbury, Massachusetts. In retirement, he worked as a school crossing guard. One day at a diner, he complained that the school's assigned police officer was often, quote, leaving his post to buy coffee. And Mr. Nichols worried that a criminal might exploit the officer's frequent absences and, quote, shoot up the school. As a result, an ex parte confiscation order was issued against Mr. Nichols. His firearms license, which had first been issued in 1958, was confiscated, as were all his guns and ammunition. It took nearly half a year before his firearms license was restored after Mr. Nichols filed suit. Under some circumstances, under some confiscation laws, A petitioner the accuser, does not need to show up in court ever. Instead, he or she can testify by telephone. And thus the judge is deprived of the ability to observe the accuser's demeanor, which is essential for a court to be able to make credibility judgments. As in other judicial proceedings, telephonic testimony should be allowed only when there is a specific showing of good cause in the individual case. Sometimes government attorneys discourage people from having counsel, even at their own expense. My written testimony includes a former Connecticut prosecutor explaining how he talked respondents out of using lawyers by warning them if they did, they'd have to pay for an attorney if they didn't go along with what the prosecutor wanted. Colorado has taken steps to prevent such abuse by making court-appointed counsel available to all respondents, whether or not they're indigent. Federal funding can encourage states to broaden the availability of court-appointed counsel. According to the U.S. Supreme Court, cross-examination is beyond any doubt the greatest legal engine ever invented for the discovery of truth. But under some statutes, the accuser and witnesses supporting the accuser never need testify and be subject to cross-examination. Instead, accusations can simply be made by affidavit, and that makes a sham of due process. No-knock raids should be the exception and not the norm. In Colorado, no-knocks require a judicial warrant issued at the request of a district attorney. But Colorado's new confiscation law was written to negate this requirement for gun confiscation orders. Violent no-knock raids for any purpose should only be allowed when authorized by a court based on the specific circumstances of a case. Law enforcement officers should not routinely be put in the position of having to forcibly confiscate firearms based on a court order for which the accuser never appeared before a judge and for which the accuser's claims were never verified or investigated by law enforcement. Finally, because perjury prosecutions are extremely rare, victims of intentionally false and malicious accusations should have a right to sue for damages. The U.S. Senate Subcommittee on the Constitution can properly exercise its jurisdiction by encouraging states to enact or improve statutes so they adhere to best practices. Thank you.
Thanks, Mr. Koppel. I'd like to now ask Kimberly Wyatt to give her testimony. And again, I think it's by remote.
Yes, good afternoon, Chairman Blumenthal, Ranking Member Cruz, and distinguished members of the Senate Judiciary Committee. My name is Kimberly Wyatt, and I'm a Senior Deputy Prosecuting Attorney from King County, Washington. I'm grateful for the opportunity to testify and share with you the importance of having an extreme risk protection order law in our state known as IRBO, and how this law has worked over the past years. You will hear about the need for IRBO implementation, the benefits of increased coordination with local and federal law enforcement, and real-life applications of how IRBO has been used to save lives. As our nation faces the most recent tragedies and senseless losses of life in Indianapolis, Boulder, Atlanta, and many others, our nation grieves, as it all too frequently does in the aftermath of mass shootings. I am here today speaking from experience to say we have an opportunity to get ahead and create a viable path forward. It is time for us to act and lean into the tools that can make a difference in curbing firearm violence. And one of these tools is extreme risk protection orders. Extreme risk protection orders are a critical tool to intervene to prevent a firearm-related tragedy from occurring. Countless reports published by the U.S. Secret Service and many others found that people who intend to do harm to themselves or others often share that information in one form or another. Being alert to this information is the key to saving lives. Extreme risk protection orders and how our unit was formed, the Regional Domestic Violence Firearms Enforcement Unit, has helped intervene and disrupt several potential suicides, mass shootings, and other threats to the community. Extreme risk protection orders allow family members and law enforcement who have seen those warning signs to come immediately before the court and petition for a temporary order that prevents the at-risk individual from purchasing and possessing firearms. Intervening at the time of the warning signs and threats can make a difference between life and death. IRBOs also have due process built in as a judge oversees each phase. As we have learned locally, IRBO laws do not implement themselves. We quickly realized the need for IRBO education. Having a law alone is insufficient. It is critically important that law enforcement and other system partners and community members are aware that ERPO is a tool, specifically a tool to prevent suicides, threats to others, including threats of mass violence. Equally essential is the need for the public to know that if their loved one is in crisis, that there is a tool perhaps that they could use. Having a designated ERPO prosecutor and advocate to help assist families, to educate, and to guide through the process of petitioning for an ERPO in real time has proved to be a successful model. Federal funding is needed to provide states a model policy to adopt ERPOs. To understand how ERPO has worked in my jurisdiction, I want to give very brief context of where I'm from in King County. King County, Washington has a population of approximately 2.2 million people and is comprised of more than 30 different law enforcement agencies. The county has densely populated areas like Seattle, but also many urban, suburban, and rural areas. In 2020, our unit assisted with 79 ERPO petitions. Now, the numbers don't tell the stories alone. We need to look at the facts of several of the cases that we assisted on. In one suicide prevention case, a father reached out to our unit expressing concerns that his son was actively suicidal, had access to firearms, and had a significant substance abuse issue. An ERPO was filed to temporarily remove the firearms from the home. The father testified at the hearing and told the court that he believes in the law of common sense and that the ERPO, this law of common sense, was needed to protect his son and family. We've also worked in coordination with federal partners on several ERPOs, including one where a federal employee made threats of mass violence towards his employer after he was placed on leave. The employee made threats that included a reference to a massive massacre in the federal workplace and stated he had nothing to live for and it was going to be a bloodbath. Our unit was contacted to assist with the ERPO, and while federal law enforcement was investigating the threats, a temporary ERPO was obtained. In coordination with law enforcement, the respondent was served and firearm parts that the respondent had purchased were intercepted by law enforcement before he could carry out his plot. In another case, in cooperation with federal and local law enforcement, an ERPO was filed against a self-admitted member of a neo-Nazi group known for promoting and advocating and advancing a violent ideology. The respondent was organized hate camps that included firearms training, access to firearms, while promoting threats of mass violence, including threats to kill members of the Jewish community. A temporary ERPO was served and numerous firearms were recovered, including ghost guns. Every example above illustrates the importance of acting when behaviors suggest that someone might be a danger to themselves or others. In so many situations, we do not get a second chance to intervene. Extremist protection orders save lives. I know this firsthand. Every state in the nation deserves to have this life-saving legislation. Thank you.
Thanks, Ms. Wyatt. I'd like to introduce Nikki Gosser. And as you begin, let me just speak, I'm sure, on behalf of the entire committee to say how deeply our hearts go out to you on your loss and really appreciate your being here today.
Thank you, Mr. Chairman. Can you hear me okay?
We can hear you.
Thank you, Mr. Chairman and members of the committee. I'm here speaking as a victim of a violent crime. I'd like to give you some insight on how red flag laws can have devastating unintended consequences for many Americans. In 2009, my husband, Ben, was shot 7 times and killed in front of me by a man who I had just realized that very night was stalking me. This occurred in a gun-free zone. I asked management to please remove the man from the establishment because I realized I was being stalked. There was no confrontation or words exchanged with my stalker. When management approached him and asked him to leave, he pulled a handgun, came up behind Ben, shot him in the head, and then stood over Ben and continued to fire 6 more rounds into him. My stalker was in complete control. He was the only one with a gun. Because of the law, I had to leave my legal permitted firearm that I normally carried for self-defense locked inside of my vehicle that night. I obeyed that gun control law. My stalker did not. When police searched his vehicle at the crime scene, they found 2 more guns, ammunition, a baseball bat, binoculars, gloves, rope, and a knife. Ben's murderer has been sending me twisted love letters for years from prison to traumatize me even further. Much to my dismay, he is set to be released early for good behavior in just 7 more years. I have very real fears about what he will do once released. This horrifying experience will be with me for the rest of my life. The days, months, and years that followed were very difficult. Depression, nightmares, grief, trauma, loss, concern for my safety were all things that I dealt with and had to work through. Put yourself in my shoes. How would you feel? I remember thinking at the time, if I just happened to pass away in my sleep, I would be okay with that because I didn't know how I could face another day. I was never suicidal, but you can see where someone may misinterpret that. If red flag laws had been in place in my state of Tennessee, even those with the best of intentions could have had an exaggerated concern and assume they were acting in my best interest by having my guns taken from me. It would be devastating for a victim like me to be unable to protect myself after this stalker violated me in such a horrific and life-altering way. If he comes after me someday, my gun may be the only thing that could save my life. Red flag laws have a real chilling effect and can cause victims to fear losing their rights if they seek help by talking with friends, family, or psychologists. Rights should never be taken from people without due process first. And mental health experts should absolutely be involved in that due process. Under red flag laws, the burden of hiring an attorney and paying thousands of dollars for a representation would be on the person flagged. Who knows how long it could take in court and how much money it would cost to regain my safety? The process is unfair and burdensome. It's not only victims who can be impacted by these laws. Anyone who has dealt with traumatic events can be affected. Police, first responders, nurses, doctors, military, etc. Research varies. There are indications that red flag laws range from having no significant effect on homicides and suicides to an increase. I learned during the murder trial that there were signs my stalker was a danger to others years before he crossed our path. His coworkers, friends, and family knew of these signs. I don't know if those in my stalker's life ever reported him to police, but if they did, just as with Nicholas Cruz, who did the Parkland attack, they didn't act. Ben's murderer threatened to kill his own secretary at his job in Florida. My stalker's father said at trial that it scared the stew out of her. He fired a shotgun out of anger at innocent hunters who were near his property. At this point, he should have been arrested, charged, and convicted. That alone would have prohibited him from possessing and purchasing firearms, but for some reason, that never happened. These are just a few examples of many. He had no criminal record and no mental illness on record, but he certainly should have. Somehow, he fell through the cracks. The people in his life back then could have Baker acted him. That's where they put you on a 72-hour hold. You have a mental evaluation. The judge looks at evidence, and there's a whole range of options. They can do the outpatient treatment, removal of guns, or involuntary commitment. I just feel that if someone is indeed a real danger to themselves or others, simply taking away their guns is not a serious response. Red flag laws are overwhelmingly used because of fears of suicide. There are other ways to commit suicide that have similar high success rates. In conclusion, I believe the focus should be on mental health services and facilities in this country, focus on education for the public, training for law enforcement, judges, and prosecutors on enforcement of existing laws like the Baker Act and those similar laws across the nation already. And please don't forget compassion for good people going through a difficult time. Thank you so much.
Thank you, Ms. Gosser. Mr. Horwitz.
Good afternoon, Chairman Blumenthal, Ranking Member Cruz, and distinguished members of the committee. Thank you for giving me the opportunity to testify on the importance of extreme risk laws and their value in preventing gun violence. My name is Josh Horwitz, and I am the Executive Director of the Coalition to Stop Gun Violence. We develop and advocate for evidence-based solutions to reduce gun injury and death in all of its forms. Ms. Gosar, I'm so sorry for your loss. Like you and like so many others, I came to the gun violence prevention movement because of my own personal loss. 32 years ago, a dear friend of mine took her own life using a newly purchased firearm in a moment of hopelessness. Back then, I did not have the knowledge or the tools to intervene effectively. I desperately wish that I could go back in time, but I can't, and I can't bring my friend back. What I can do is what I'm doing right now, encouraging policymakers like you to use your power to support life-saving policies like extreme risk laws so that no other family or friends have to experience this type of heartbreak. Gun violence in our country remains persistently high, taking nearly 40,000 lives each year. 60% of those deaths are suicide. Although no single intervention will serve as a panacea to the epidemic of gun violence, extreme risk laws, which help prevent lethal violence before it occurs, have the potential to save many lives and are gaining traction throughout the country. Enacted in blue and red states alike and endorsed by both the Trump and Biden administrations, this policy provides a clear opportunity to find common ground in stemming this ongoing nationwide tragedy. In the months that followed the Sandy Hook shooting, the national dialogue around preventing gun violence was focused on mental illness. To determine whether this approach would be effective, I convened a group of the nation's leading researchers to identify risk factors for violence and to formulate evidence-based policy recommendations. When reviewing this research, this group, who became known as the Consortium for Risk-Based Firearm Policy, concluded that firearm prohibitions based only on mental illness diagnosis are not supported by research and the evidence and are harmfully stigmatizing. Instead, we identified behavioral risk factors for violence that are supported by research, including violent behavior, threats of violence, and risky alcohol use. We know that in many high-profile shootings and firearm suicides, family members were often the first to know their loved ones were in crisis. Unfortunately, there were few tools for family members and law enforcement to use during these moments. To address this gap, the consortium developed the modern-day Extreme Risk Protection Order, based on long-standing domestic violence restraining orders found in every state, as well as established risk-based firearm removal laws in Connecticut and Indiana. Today, a total of 19 states and D.C. have extreme risk laws on the books. There are usually two types of extreme risk protection orders: temporary ex parte orders and final orders. These processes have been found to be constitutional by courts across the country. In some cases, the temporary order, which typically lasts 14 days, provides enough time to mitigate risk, and it becomes unnecessary to go for a final order. Importantly, both temporary and final orders, which typically last up to 1 year, are civil and not criminal. They are time-limited and ensure processes are in place for returning the respondent's firearms at the conclusion of the orders. Multiple studies of extreme risk laws have found that they are especially effective in preventing suicides, and new research suggests that they may help prevent mass violence as well, including school violence. However, extreme risk laws can reach their full potential only if they're implemented effectively and fairly. I've met with people around the country, hosting forums about extreme risk laws and learning from stakeholders putting them into practice. And the use of those laws vary not only between states, but between cities and counties too. These variations are typically a function of training and staff. Although extreme risk laws are a state-level policy, the federal government can play an important role by supplying resources to advance state implementation efforts. By supporting local jurisdictions to train law enforcement officers, judges, and clerks, the federal government can help to assure safe and equitable application of extreme risk laws, access to services for respondents, and proper reporting of records to the NICS system. Unfortunately, this month's mass shooting at the Indianapolis FedEx warehouse highlights the devastating effect of a failure to implement an extreme risk statute. Had an extreme risk order been obtained, 8 families might not be grieving right now. We cannot allow these cases to fall through the cracks for lack of resources and training. Too many lives are at stake. Gun violence is preventable, and while I'm sure that every member of this committee does not agree with every nuance of every extreme risk law, I hope that we can agree that temporarily removing firearms from a person at high risk of violence is the right thing to do, and that we can do it in a way that enhances community safety while respecting constitutional rights. Thank you for this opportunity to testify. I look forward to your questions.
Thank you very much, Mr. Horwitz. I'm going to begin with some questions. We are actually, I believe, in the middle of a vote, and so we may kind of tag team. We may have to take a recess briefly, but I will begin the questioning. Let me ask you, Mr. Horwitz, I don't know of any red flag or extreme risk law that has been struck down by any court across the country.
You are correct.
And why would you say that is, given all of the hullabaloo that we've heard about due process and constitutional rights?
I would say that's because it's built on the same process as the domestic violence restraining order, which has been found again to be constitutional. It's a very similar situation. So instead of, for instance, a spouse worried about the risk to them from another spouse, for instance, what happens in a situation where the spouse is a danger to themselves? Right? It's the same risks, the firearms in play, the same risk factors, the threats of violence. So judges have a good sense of how that works, and it's the same standard from state to state. So I really think we built it on this domestic violence restraining order process, well established, all 50 states. Courts know how to use it. I think that's why they've been found to be constitutional.
And I've heard the argument made that red flag laws are unnecessary because we have domestic violence protections. Is that true?
Well, I think, especially in the case of risk to self, right? I mean, that's a big issue where, a domestic violence restraining order, you can't get, it's not available for someone who's at suicide, at risk of suicide. Additionally, there's, when you think about it's broader, here law enforcement can go and use it, a civil order in many situations. So it's broader than a DV law, but built on the same process with the same protections.
And in fact, the target of a shooter may not be somebody at home. It could be a school. It could be someone at work. It could be a stranger who's stalked. It could be anyone.
Right. When you look at the examples, you often see that the person who is at risk may not be in any relationship at all to the shooter. And so this gives that opportunity for law enforcement to intervene, and it gives them clear legal authority to intervene, which is very important.
The claim has been made that the process for regaining a firearm is costly, it's burdensome. Is that customary?
When the order expires, the firearms get returned. So the same way this works, it's again a civil, not criminal process. These are quick processes, and typically in the United States, we don't. Lawyers are not provided for protective orders, the same as DV laws.
And if the firearm is retained, the burden is on the prosecutor or the official who wants it to be retained to prove that there is some danger, some severe risk, and it's called extreme risk for a reason. There is extreme risk, and the burden is to prevent evidence, not just make the claim, correct?
Well, it's two stages. You have the temporary where you have to make the claim, and the we call it permanent, although it's for a year, where you have to make that claim, and you have to prove it twice in most cases, and oftentimes the burden of proof is higher the second time around.
In fact, the burden is always on the prosecutor, and it often is.
So,
higher.
and just I'm sorry.
Let me just ask Ms. Wyatt, because you have a unit consisting of law enforcement, prosecutors, a court advocate, a problem solver, a court coordinator, a paralegal, a data technician, and a program manager who all assess the danger before you even go to get a warrant that separates someone from a firearm. So you are extremely cautious and demanding of yourselves before you exercise that power. Is that correct?
That is correct. And we are carefully vetting those cases, typically with law enforcement as well, And so we are going through to make sure, one, ethically, legally, it meets the standard for an extreme risk protection order. And in our state, so we're going to have to petition with the court to be able to prove that the individual is a significant danger to themselves or others. And then there's a series of factors that we're basing that off on. And that typically involves a threat of self-harm or threats to others. But you're absolutely right that there are many different layers built in to the process. And as you can see, I mean, we have a population of 2.2 million people, and we filed last year, or assisted filing with law enforcement and families, 79 GERBOs. So I believe that's less than 0.002% of the population. So we are very specific and targeted about our work.
But it takes resources to run that kind of unit. And that's exactly the kind of resources and support we would try to provide through this legislation for state statutes. Again, we're not talking about a federal mandate. It's state statutes that would be supported and encouraged and incentivized. Mr. Bencomo, let me just finish with a quick question to you. In your experience, I think that a very substantial proportion of victims of suicide are, in fact, veterans. Why is that?
This is a personal thought, is that there's a stigma within the veterans community to seek mental health. We are trained warriors for this country. We're strong, we're patriotic, we have a job to do. And at times we can't allow some of our personal emotions to get in the way. And that carries on once we leave service. And it's a very strong, empowered defense for us. And that's probably one of the reasons why many of us will not seek mental health when we're asked to or need to.
And often the effect of going to court in a red flag case has the effect of persuading a veteran to seek help. Is that correct?
I would say if they were required by the court, then yes, they would have to, by the nature of the case, would have to then seek some type of mental counseling.
Thank you. Senator Cruz?
Thank you, Mr. Chairman. And I will note, Mr. Chairman, I was remiss at the outset of this hearing in not congratulating you on being chairman of this committee. I had the pleasure of being chairman of this subcommittee for the past couple of Congresses, and it is a terrific committee with I think, the best jurisdiction in the entire Senate. So I look forward to serving with you as ranking member on the committee.
Thank you.
Mr. Koppel, last time you and I spoke, I asked you what the minimum protections that an extreme risk law should have to ensure that it comports with due process. You responded that laws should not allow ex parte proceedings except on a finding of necessity, that laws should use a clear and convincing standard throughout, and that respondents should have a right to counsel and the right to cross-examination. Do any of the laws currently on the books meet all of these criteria?
There's no one state that has all of them. In several states, you can pick things from several states that are good on a particular item, but no state law has the full scope of what I would say is fair for due process. And as Senator Blumenthal and Mr. Horwitz discussed, there haven't been very many constitutional challenges on this, but the ones that have been not very successful, have failed, and partly because they were very broad kind of facial attacks. The bigger picture is courts aren't always our leaders in protecting due process. Civil asset forfeiture, I think, is now something that people say went way too far and it has been reformed by statute. But judicially, there was very little that ever got done about that, and most of the challenges failed. So there's the kind of most minimal level of due process the courts will enforce, and then there can be higher, better standards that legislatures insist on.
So President Biden instructed the Department of Justice to develop a model red flag law for the states. Last time you were here, we discussed the fact that Giffords, a progressive gun control organization, blocked the drafting of a model red flag law by the Uniform Law Commission because they insisted on their own more extreme model. I'm concerned that the Department of Justice will put out a model law that is more or less the same as Gifford's extreme model. Can you tell us, in your judgment, what that model looks like and why it's so extreme?
It's a model that on the one hand doesn't view the temporary, whether for 2 weeks or even a mistaken thing for much longer, deprivation of the right to arms as a significant harm. So its premise is somewhat unbalanced in how it weighs things. And it's ultimately something that's based on one side of the issue, which is understandable. That's the faction that won the election and controls the presidency. But what was going on in the Uniform Law Commission was to take into account both points of view. So, for example, one group in the commission was the International Association of Chiefs of Police, which is has been for decades, a very pro-gun control organization. And on the other hand was the National Sheriff's Association, which is definitely not absolutist against gun control, but is more typically skeptical. And so if you had both of those perspectives, and I think that would lead to a more balanced, fair, and accurate process. Because I think there's agreement that there's some people from whom guns should be taken away for public safety. And also there has to be recognition that sometimes mistakes happen and people are improperly deprived. And we want to get a process that has the highest possible feasible level of accuracy.
So President Biden has nominated David Chipman, who is a senior policy advisor for Giffords, to be the director of the ATF. I understand that you have a bit of history with Mr. Chipman regarding red flag laws, and that he seemed not to have great concern about law-abiding citizens having their right to self-defense stripped away. Could you give us some background on what happened with Mr. Chipman?
Sure. He was on the commission, a member of the Uniform Law Commissioners Study Committee with me. And I brought up, as you mentioned, I brought up the problem of we want to make sure we don't disarm innocent people, even on a temporary basis, because that creates danger for them. And then his response was, well, people can just buy a replica gun, and maybe if they're a great actor, they can scare people away with a replica gun, but that's not really an effective alternative to an actual firearm for lawful self-defense. And another part in the discussion, I said, I brought up the point about no-knocks. And in general, of course, no-knocks are necessary in some situations, but we want to have them used when they are necessary and not just routinely. And we've seen lots of situations outside of red flags where no-knocks just get carried out kind of in a reckless way because the local SWAT team doesn't have anything else to do that day. Mr. Chipman's response was, don't tell the police how to do their job. Well, I guess as a constitutional law professor, and my dad was in the state legislature as a Democratic liberal representative from Northeast Denver for 22 years, we tell police how to do their jobs all the time. That's what the Fourth Amendment to the Constitution does. The Fifth Amendment does that. And so do all kinds of statutes we have in this country.
Thank you, Mr. Koppel. And a final question, Ms. Gosier. Thank you for appearing today. Thank you for telling the story of the horrific murder of your husband. And thank you for using the pain and horror of that crime, using it to try to protect others who might be victims of violent crime in the future. Your husband was murdered in a gun-free zone, and you followed the law. You did not have your firearm. You were not able to protect yourself or protect him. That is a familiar pattern with gun control efforts, and many of the mass murders we've seen have occurred similarly in so-called gun-free zones. Are you concerned that the same will be true with red flag laws, that law-abiding citizens could have their firearms confiscated, particularly when they're vulnerable to criminals, but the criminals will refuse to turn over their weapons, and the result will be other potential victims of crime being left vulnerable to violence?
Yes, absolutely. I'm very concerned about that. Of course, there are people who can abuse red flag laws. there are people that can abuse existing laws too, but, at least with the Baker Act, different states call it different things, but we pretty much have an option that is the Baker Act. They call it different things in different states, but it exists all over the nation. Every state has a similar law to the Baker Act, and they offer protections. I don't have $10,000 in my savings account to cover legal fees if someone flags me for some reason. It's pretty scary that someone could knock on your door, or law enforcement knock on your door at 5 a.m. and say, hey, we're taking your guns, and you have no idea why. You don't know why. What's going on? I need to be able to protect myself. I just think due process is so important. And mental health experts should always be involved. That should be mandatory. If we're talking about mental health experts should absolutely be involved in that due process. I believe due process needs to come first. Look, if someone is truly, they need to be confined to a mental health facility. So you take someone's gun away. They're still dangerous. That's how I feel.
Thank you.
Thanks, Senator Cruz. Senator Whitehouse.
Blumenthal, for this hearing and for your long time passion and leadership for protecting our people from the scourge of gun violence. Mr. Horwitz, we passed a red flag law in Rhode Island. It went into effect in June of 2018, and the last report I have ends with data as of November 2019. In that period, state and local police in Rhode Island invoked that law 33 times. In one of our municipalities, Cranston, police petitioned for red flag orders 8 times, just in one city. In one case, police seized weapons and obtained an order to help a worker who had made comments he had a desire to kill certain coworkers and had boasted about his firearms. Is that experience in Rhode Island consistent with what you see around the country in terms of the
I think
laws
it is.
Being made effective?
I think it is. I think we're seeing it used very judiciously. I think we're not seeing millions of these being done. I think there's in Virginia, where I'm very familiar, there's under 70 or so even in the first year. So I think it's very consistent with what we're seeing around the country. California in the first couple of years saw under 400 in such a big state, but they're very important. They're based on someone's, on the risk of individuals, and I think that's why they're not used for mass, for lots of people across a wide spectrum. They're individualized attempts to identify people who are at an elevated risk of violence, and I think that's why they're important, that's why they're constitutional, and that's why they're effective.
Ms. Wyatt, those of us who've sat in a prosecutor's chair and had to make the decisions that you have to make are familiar with a whole variety of legal procedures that help protect people from threats of violence, whether it's restraining orders, protective orders. They're particularly common in the domestic violence arena. In your view, are the protections involved in the red flag laws consistent with those for other types of safety orders that law enforcement commonly obtains?
Thank you for the question. Yes, you're exactly correct in that extremist protection orders follow the process similar to domestic violence protection orders or sexual assault or anti-harassment orders, meaning that each phase comes before a judicial officer. So a family member cannot walk off the street and get an ERPO on their own, nor can law enforcement. They have to sign and fill out a detailed petition signed under penalty of perjury, and then it's submitted to the court just like any other civil order would be. And the court is making a determination if they're, in our state, reasonable cause that the individual is a significant danger to themselves or others. So similar process with other civil protection orders as well. And then the individual subject to the order has to be served, because that individual needs a chance to be able to come to court, to have their own witnesses, to be able to tell the court either they're in favor of the order or they're going to challenge that order. So each phase and each step involves judicial oversight.
In particular, Ms. Wyatt, do you think, just as a matter of good practice, it would be advisable to have domestic violence victims or those who have a restraining order protecting them from another individual be advised when that individual, their assailant or the threat to them, acquires or tries to acquire a weapon, a firearm specifically?
Yes, and our unit specifically addresses not only extreme risk protection orders, but of course also domestic violence protection orders. And because the lethality is so high at the moment that those victims are petitioning for separation or petitioning the court for a domestic violence protection order, it's critically important that we follow up and enforce court orders when they're ordered to surrender weapons, like in our domestic violence cases or and our state has a system set up to notify if somebody's subject to an order and somebody attempts to purchase, or if we get notification from our state patrol, and then it goes to local law enforcement as well as our unit. And then we have victim advocates that are reaching out to the victims as well to make sure that they know that there is either an attempted purchase, or if a firearm was actually delivered, then we're going to be following up with local and federal authorities if we believe that the firearm was given to somebody who should not have it.
If I could ask one more question, Mr. Bencomo. Sure. I think it's human experience that powerful emotions can pass through human beings, anger, rage, jealousy, and that the decision-making during that period when you're in the grip of a fierce emotion can be compromised, and the people act out in unfortunate ways in that moment and make decisions sometimes that have irrevocable consequences for the rest of their lives. Given that aspect of human nature, is it conceivable that the subject of a restraining order, the person who is told they have to take a pause on having their firearm, is actually the real beneficiary of that restraint?
A simple response would be yes.
Yeah, it just seems that way. You lose your access to your firearm for a week or two, and you're spared a lifetime of guilt and remorse, and the horrible memory of having acted on something when you were in a fit of emotion. Seems that way to me anyway. Thank you.
Thank you.
Thanks, Senator Whitehouse. I'm going to call on Senator Lee. I'm going to vote if I am not back by the time he is finished with his questioning. He's going to call a brief recess. I'll be back, and we can resume then. Thanks, Senator Lee.
Thanks so much, Mr. Chairman. I really appreciate you accommodating me in that regard. Thanks to each of you for being here today. You know, the Second Amendment guarantees our right to keep and bear arms. This was a right that our founding fathers deemed fundamental, so much so that they added it to the text of the original Constitution. It's not only the Second Amendment that's at stake when we talk about things like this. There's also the concept of due process. The Fifth Amendment's due process clause, of course, provides that no person shall be deprived of life, liberty, or property without due process of law. That requirement is, of course, made applicable to the states through the 14th Amendment. You see, our freedom isn't free. Whenever government acts, it does so inevitably at the expense of individual liberty. That's where government has to get its power. We need government, and just the same, we need government to respect boundaries on its own authority. I certainly agree that we should take steps wherever possible to make sure that people who shouldn't have guns don't have them. In particular, those who are legally prohibited from having them because they're adjudicated as mentally unfit to do so. They've been convicted of a crime. These restrictions are consistent with our system of laws, and they can be applied in a manner that doesn't offend our constitutional rights. Ms. Gosar, I'm very touched by your testimony as I read through your written testimony. I couldn't help but notice that as you're talking about difficult things and the difficult circumstance in which you had to witness your own husband's murder, even while you had a firearm and had access to it, but you chose to comply with the law, your assailant did not. And I think you summarized it extremely well with just a few words. I obeyed that gun control law. My stalker did not. I don't think I've found any one sentence that better summarizes the need to respect the Second Amendment, the need to protect due process, and also the dilemma that we face and that we have to take into account whenever we choose to enact laws infringing upon those rights. It sounds to me like you would likely agree with the proposition that it's not a cost-free action for the government to take, that in the name of protecting people from the horrors of gun violence, government can also inflict violence. Would you care to elaborate on that, based on your experience?
Well, I think that there's some laws that are created that they have unintended consequences. I think some of these gun control laws were created thinking that, we're going to protect people. And unfortunately, it can make some people out there vulnerable so that they can't protect themselves and their loved ones. And, I don't want dangerous people to have access to guns, but you know what? I don't want them to have access to a vehicle or a knife or a baseball bat or a pressure cooker. I mean, if they're truly dangerous, of course, I want everyone to have due process. I believe murderers deserve due process and victims as well. That's what's so great about our country, that we do have due process and we do have a constitution. I don't want to live anywhere else. I love America, and I love that about America.
And yet it's sometimes suggested, and we've heard it suggested even just in the last few moments, that the worst that can happen if you take somebody's gun away without due process is that they have to go without it for a few days or for a couple of weeks. And yet your circumstance would seem to suggest that that is not true, that that is not the full extent of the downside of that there is more cost. And sometimes that cost is borne not just in an inconvenience, but in someone being left vulnerable.
Yeah, absolutely. In my case, it would have compounded the problem. Of course I was depressed. Who wouldn't be? Of course I had nightmares. Who wouldn't after going through that? But to take away my basic human right of self-defense on top of all of that would just be devastating for someone like me.
Sometimes people will argue due process is great and everything, but with respect to the bad folks, well, we can't give them due process. Isn't that the problem with due process itself? I mean, if we're going to respect due process, aren't we agreeing up front that due process needs to be up front? It's not really due process if it's only after the fact. Is that right?
That is right. And I understand it can be very scary. I mean, I get it. I get it. I'm a victim of a violent crime. But like I said, if you truly believe that someone is a danger, they should be confined to a mental facility, but they should have due process. And that's why I support the Baker Act and similar laws that already exist all across the nation. Every state has a similar law to that because it includes due process. Your legal fees are covered. They're not under red flag laws. I don't have $10,000 to cover legal fees. It can be very, very expensive. And with the Baker Act and similar laws, mental health experts are involved. That's not always the case with red flag laws. And I think that's very important that mental health experts be involved in that due process.
Mr. Koppel, does lack of notice and due process, it sometimes might go along with gun confiscation orders, doesn't this have some potential to increase the risk of harm, both to law enforcement officers executing the orders and to those who are subject to those orders?
Sure. I mean, you imagine a situation where officers, there's a ex parte order that's been issued, and maybe it's on weak evidence and the guy's really not dangerous, but the confiscation order is served by the police showing up at somebody's house at 5 o'clock in the morning. Normally, where a homeowner might think it was a burglary, and because he has no idea that anybody's coming to take his guns. And there's also a broader problem in how it erodes trust between law enforcement and the public. And this was talked about in one of the Connecticut studies that's quoted in my written testimony. When you have somebody whose guns are taken away and confiscated, the police show up. I've never heard of anything going on against me, but now there's a cop coming to take my guns. As some Connecticut State Police officers have reported, these are often the guys who think of themselves as the most pro-cop. They're the ones who are on the back the blue, on the side of law enforcement, understand it's a tough job, and then all of a sudden the guys they thought they were their friends are there to take away their property, when it's a complete surprise to the person. And then maybe a few weeks later, the person hires a lawyer, goes into court, they get their guns back. But in the meantime, it's been a very humiliating process for the wrongly accused individual. And law enforcement, who I've often represented in amicus briefs in courts and elsewhere, are so dependent on the cooperation and goodwill of the public. That's the American model. We're not policing from above like in some other less free countries. So when these are done wrongfully, they really break that relationship and bond between the public and law enforcement that is necessary to successful law enforcement and public safety.
Mr. Koppel, there are a number of us, myself included, who have formed sort of a bipartisan coalition raising concerns in a related area of civil asset forfeiture, where in areas outside of firearms, we've raised concerns with law enforcement being able to take people's property first and then ask questions later, to take first and then provide some sort of process later. Due process, of course, has a higher expectation than that, does it not? And do you see tell me what you think about the parallel between this and that. In other words, if one is concerned about the potential for abuse and the actuality of abuse in the civil asset forfeiture arena, how could one not see something similar when it extends to the Second Amendment?
It's the same kind of situation. It is a similar kind of situation, and both have good intentions of trying to deal with a serious problem. Here, gun crime and civil asset forfeiture, it had always existed in kind of a minor way, but it really got ramped up in a huge way in the 70s and 80s because of the drug war. And of course, drug abuse can be very harmful, not only to an individual, but to society more broadly. And so the idea was, well, we need these tools to fight the drug lords and all this. And what happened was there were a lot of people whose property got taken who weren't Colombian drug lords or anything like that. And it was widely abused. And sadly, the courts, in their view of what the Constitution requires as a minimum for due process, generally said that's fine. So I would urge this, especially this committee of all committees in the United States, which is charged with defending the Constitution, that one of the reasons courts often defer to legislative judgments is they presume, just like Chief Justice Marshall said in McCulloch versus Maryland, that the legislature itself already seriously thought about constitutional rights and values. So I think legislators can and should go above whatever minimal level the judiciary will enforce in terms of the protection of people's procedural rights.
So insofar as we're talking about a due process right that is freestanding here, which I think we've agreed that there is, certainly a right doesn't lose protection by becoming a hybrid right. In other words, if you already have a freestanding independent due process right protected by the Fifth Amendment or the 14th Amendment's due process clause, you certainly don't see that any justification for diluting that right merely because you've added the Second Amendment into the equation by virtue of its involvement in the firearms arena.
Yes, at least as a policy matter, you would think due process would be all the stronger there. And of course, the analogy, as I'm sure you know, in the first Supreme Court's free exercise of religion jurisprudence, sometimes that free exercise of religion gets stronger protection when it's a hybrid in conjunction with the exercise of some other right.
Right, right. I've never quite understood the hybrid rights doctrine in the First Amendment context beyond what you just described, which is that it certainly doesn't get weaker when you compound one right with another. And I would maintain that that is no less true here. Consistent with the directive I was given from the chairman when he left to go vote, I hereby recess this hearing of the subcommittee subject to the call of the chair, who will be back momentarily. Thank you.